Hello, good evening. I'm so happy to be with you all today. My name is Akeisha Lee, and I am with Southsiders Organized for Unity and Liberation, also known as SOUL. And SOUL is proud to be a member of the Illinois Network for Pretrial Justice. The Illinois Network is made up of over 45 organizations working across the state to end money bond and reduce the harm of pretrial jailing because it has harmed so many communities across our state. In January 2021, we helped to pass the Pretrial Fairness Act. And this historic law will make Illinois the first state in our nation to end money bond. Hope y'all are clapping out there because I'm excited about it. Okay, so tonight we're going to take a deep dive into understanding the lawsuit that has pushed back the Pretrial Fairness Act. We'll be joined by Kareem Butler and Sarah Stout of Chicago Appleseed. They're also members of the Illinois Network for Pretrial Justice. We'll also be joined by Margaret Truesell of Hughes, Skokel, Pierce, Resnick, and Dim. They're one of the firms that filed the amicus brief that was supported by our network and more than 400 elected officials, faith leaders, and organizations across the state. So first up is going to be Kareem. He's going to talk to us through a short explanation of what the Pretrial Fairness Act is. And then Sarah will give us a rundown of how the lawsuit got into the Supreme Court, and Margaret will give us an overview of the amicus. And then we'll bounce back to me for a quick question and answer. And with that, I'll hand it over to Kareem.
Thanks, Akeisha. Hi, everyone. My name is Kareem Butler. My pronouns are he, him, his. As Akeisha said, I work with Chicago Appleseed and the Illinois Network for Pretrial Justice. So I'm going to just go over an abbreviated run through of the Pretrial Fairness Act and some of the different provisions that are really core to this law, and really explain a little about why these different aspects of the law are important in reducing unnecessary jailing and also curbing the harms of pretrial incarceration. We'll start with the first and perhaps the most notable change the law makes in abolishing money bonds statewide, otherwise known as a practice of attaching a price tag to someone's freedom. So the Pretrial Fairness Act eliminates this practice. This practice does fuel a lot of unnecessary jailing. And the reality is that right now, under the current system, the majority of people who are sitting in jail are there simply because they cannot afford to purchase their freedom and go home. And they're also, of course, dealing with all the negative fallout and the consequences that affect their lives in other ways as a result of that. Beyond abolishing money bond, the law seeks to accomplish other ways of reducing unnecessary jailing. One of the other features of the law is the creation of a detention eligibility net. This essentially means that for the majority of individuals who are facing low-level charges where there is no safety threat or there is no likelihood that they will willfully flee prosecution. These are the majority of individuals appearing in bond court today. They should be able to go home pre-trial while they await their future court dates. There is a process that the court can follow for individuals facing more serious charges where there is a real safety threat or a likelihood that an individual will willfully flee prosecution. But this is just to make sure that we're, again, reducing unnecessary jailing and limiting the court's ability to automatically impose pretrial incarceration upon people. The law also diminishes the role of risk assessment tools and regulates their use in court so that they will not be the sole determining factor in whether or not someone goes home or is detained pretrial. Risk assessment tools bake in a lot of racial and economic bias, so it's important that they don't have an outsized decision-making role in pretrial systems. And under the new law, defense attorneys will now have access to the criteria that is baked into these risk assessment tools. And accused people will also be given access to the criteria baked into these tools. Essentially, what they do is spit out a score that says so-and-so is a 4 out of 6 on the scale of how likely they are to reoffend pretrial. And so that is an important way that the law also diminishes unnecessary jailing. The law also authorizes release by law enforcement to further reduce unnecessary jailing, even for a short period of time, as short as a couple of days, through a provision that is known as cite and release. So for individuals facing very minor offenses, things as simple as jaywalking, law enforcement is authorized to cite and release individuals on the spot. even in situations where an arrest has occurred, if there is no real safety threat, law enforcement is authorized to cite those individuals and release them from custody. The next thing the law does is reduce penalties for violations of release conditions. So under the Pretrial Fairness Act, this is a process has been created where the court can determine whether or not any violation occurred willfully. Technical violations are no longer grounds to incarcerate someone all the way up until their future court date, or all the way up until trial, rather. And the penalty for those technical violations for most misdemeanor violations has been reduced as well. The next thing the law does is require reconsideration of detention and release conditions. This is important because for situations where an individual has been ordered to very restrictive release conditions, or an individual has been incarcerated pre-trial, now under the Pretrial Fairness Act, the court is required to periodically at each court date reevaluate whether less restrictive set of release conditions can be imposed upon the individual while still ensuring public safety and future court appearance, or whether it is necessary to continue incarcerating that individual to ensure public safety and future court appearance. In addition to that, the law also makes some changes to electronic monitoring by ensuring that people who are ordered to electronic monitoring, specifically home confinement electronic monitoring, receive credit to any potential sentence they are given upon conviction. So, for example, if an individual spends 2 years on home confinement electronic monitoring and they are subsequently convicted at trial, if there is any prison time that they would have to serve, the 2 years that they spent on home confinement electronic monitoring is to be credited towards any potential sentence. And then in addition to that, as I said, people are required to be given movement periodically throughout the week. This is so that individuals can carry out basic tasks to handle important necessities, things like going to the grocery store, handling doctor's appointments. In addition to that, the law does make some changes to the warrant process. So if individuals, for example, fail to appear at a specific court date, the law does equip judges with alternative means of encouraging people to come to court rather than forcibly bringing them to court by issuing an arrest warrant. So judges can, for example, if someone were to miss court, issue a notice to appear. And in order to ensure that people appear in court, judges are also equipped with the option of issuing court reminders. These are simple things like text message reminders, automated phone calls to remind people of upcoming court dates. Finally, the law also makes some important changes to the way that data is collected in relation to our pretrial system, in the way that information is publicized. So right now, there's little information that we know about what's happening in our pretrial systems in terms of what bond court outcomes people are experiencing, what charges people are facing, the demographic information of people moving through our pretrial systems. All of that information is really important to us as advocates so we can better hold our system actors and our court actors accountable. And so the creation of this process is an important means in increasing accountability. With that brief overview, I'm going to pass it off to my colleague, Sarah Stout, who's going to give people an update on the ongoing litigation and explain a little background behind that lawsuit.
Sure. Thanks, Kareem. So as Kareem said, this law does a whole lot of different things. We were very excited to have it passed in January of 2021, and then there was some substantial updates to the law to clarify some provisions that were made in December of 2022. So there's been a ton of action around the law in the last year. And that has ginned up our opposition, people who are opposed to the law, as well as making us all really excited. So in September of 2022, a group of prosecutors and sheriffs from about 60 counties filed a lawsuit claiming that the Pretrial Fairness Act is unconstitutional under the Illinois state constitution. I'm going to get into what their arguments about that are in a sec. Because all of these lawsuits were basically the same lawsuit, in fact, many of them were just copy-paste filings from one county to another, the Supreme Court had the prosecutors consolidate their lawsuits in one county. when that happens, you're allowed to choose what county your lawsuit is consolidated into, and the county that was chosen was one that was very conservative, Kankakee County, which is south of the city, and that is where the first court to hear the lawsuit is based. Next one. Can you go to the next slide, please? So there's a judge. So the judge in Kankakee is named Judge Thomas Cunnington. He is a Republican and a former prosecutor, which is important because fundamentally these lawsuits are political in nature. They are being brought by a group of people who have policy disagreements with the Pretrial Fairness Act and don't believe it's a good idea. And that's ultimately, we believe, the real reason that these lawsuits are being brought. This judge has made clear from his opinion that he also does not think the Pretrial Fairness Act is a good idea. And he ruled in favor of some of the prosecutor's arguments. In doing so, he ruled that the Pretrial Fairness Act is unconstitutional under the Illinois Constitution. For those of you who pay a lot of attention to national level things, it's important to note we're not actually talking about the federal constitution here. We're talking about Illinois' state constitution and the language that's in those provisions. So that happened right after Christmas. There was a ruling that said the Pretrial Fairness Act is unconstitutional. At that point, things became a little complicated. It was not particularly clear directly after that ruling was made exactly which counties the ruling would apply to. And directly after the lawsuit, what we thought was going to happen was that the Pretrial Fairness Act would go into effect in some counties and not into effect in other counties, in the counties where the suits had actually taken place. But that would have created a lot of confusion, right? It would have meant that Cook County had one system and then the county next door might have a different system. So two prosecutors who were notably not parties to the lawsuit, Bob Berlin of DuPage County and Jamie Mosser of Kane County, filed a motion with the Illinois Supreme Court basically saying, we're not parties to the lawsuit, but we have an interest in how this case gets administered because we're prosecutors who, among other things, have jurisdictions that cover, we have cities in our jurisdictions that are in multiple counties, right? So like Aurora, for example, is in Will County and Kane County and DuPage County, I believe. Might have gotten those counties wrong, but it's in multiple counties. And they pointed out basically that there would be a lot of confusion if some counties were implementing the Pretrial Fairness Act and others were not. So what they asked the Supreme Court to do was stay or stop the implementation of the Pretrial Fairness Act in all counties so that there'd be consistency throughout the state while we're waiting for the Supreme Court to make a decision. And the Supreme Court granted that request. That happened like literally, I think, on December 30th or December 31st. And at that point, that's sort of where we are now. The Pretrial Fairness Act is paused. The implementation of that law is paused until the Supreme Court makes a ruling on whether the lower court was right in the way that they made their decision. Next slide. So what happens next? So the first thing that happens after there was a ruling that didn't go our way was that an appeal was filed. The Attorney General's office is the office in the state that is tasked with being the lawyers to defend the constitutionality of laws. When somebody says a law is unconstitutional, in general, it's the Attorney General's office who's actually the lawyer in the case who defends the law. And that's what's happening in this case. So the Attorney General's office appealed the Kankakee judge's order. There's another rule in Illinois law that says that when constitutionality is at issue, we skip any appellate courts and we go directly to the Supreme Court. So luckily, we don't have to wind our way through multiple courts. We're going to go directly to the Supreme Court. And the Attorney General's office has filed their appeal. The timeline that has been set now is on an expedited timeline. Now, I'm going to describe the timeline, and it may not sound expedited to you, but as a lawyer, I will say, I swear it is. Normally, these kinds of cases could take, upwards of a year to resolve. In this case, the Supreme Court has put it on an expedited briefing schedule. And what that means is that briefs, meaning the written filings that make the arguments about whether the lower court was right or wrong, are being filed. One at the AG's office, the Attorney General's office brief actually has already been filed. The response brief will be filed in February. Oral arguments in the case will be held in March. We don't have a specific date, but we know that they will be held in March. After that, the timeline becomes a little speculative. The Supreme Court could rule sort of at any time after oral argument, but it usually takes them a couple months to put together an opinion and actually issue a ruling. So the best we can say is that we are expecting a decision probably in May or June. So that's sort of the timeline that we expect. What we know for sure is that we'll have oral arguments in March. After that, we're really speculating on how long exactly it will take for the Supreme Court to make a decision. So, okay, so let's talk about what these arguments are and why we think, and more than we think, why the Attorney General's office thinks, and why in general we're pretty confident that the Supreme Court will agree that they don't really hold water. There's two main arguments that the prosecutors in this case are making where they're about why they're claiming that the Pretrial Fairness Act is unconstitutional. The first thing I'll say is that as somebody who's been involved with this campaign for a long time and just thinking about the campaign as a whole, obviously the Pretrial Fairness Act did not, was passed with the understanding that it was constitutional. And the reason that we believe that it was constitutional is because it is. There's been a lot of examination of the Illinois Constitution as it relates to bail in the past couple years. There was a Supreme Court commission, the Illinois Supreme Court Commission on Pretrial Practices, that considered what was said in the Illinois Constitution about bail and bail issues. So there's been a lot of thinking around these issues. It's not like this is the first time somebody's talking about them. But these arguments but here are the arguments that are being made. The first argument that's being made is that the Pretrial Fairness Act violates the Illinois Constitution because in multiple places in the Illinois Constitution, the word bailable appears. So there's a phrase that says, all people must be bailable by sufficient sureties. There's also a part of the Constitution called the victim's right, in the victim's rights part of the Constitution, that says that victims' rights and opinions should be taken into account when setting bail. So the word bail appears a lot in the Constitution. And the prosecutor's argument is really very simple. They say, well, bail means money. Bailable means letting somebody, have a money bond set. That's in the Constitution, so you can't get rid of money bail. The reason that's not the case is that that's not what bailable means. That's often the way that we talk about the word bail when we talk colloquially, right? We think of bail as being the amount of money that you pay in order to get out. But that's actually a pretty recent understanding of what the word bailable means. Bailable actually just means releasable. So the process of bail is the process of releasing someone from custody. And money bail is just one condition that can be placed on someone's release. So when the Pretrial Fairness Act gets rid of money bail, it's not making anyone not bailable. It's not making anyone not releasable. It's just changing what the conditions are that can be placed on someone pre-trial when they're being released. And it removes that ability to place money as a condition on people because money doesn't work. The second argument is a more general argument. And what it says basically is that it gets back to a concept you might remember from like 8th grade civics called separation of powers. Separation of powers is basically the idea that there's different branches of government, the executive, the legislative, and the judicial. They all have different roles, and there are times when they can't encroach on each other's roles. And there are a lot of rules about what kinds of decisions are let to which branch of government. What the prosecutors in this case are saying is, okay, the power to set money bail, the ability to specifically say, I want you to pay money in order to come back to court, is so central to what courts do that it's within what they call the inherent power of the courts. And then they say, because it's in the inherent power of the courts, the legislature can't make any rules about it, and importantly, can't get rid of the ability to set money bond. Margaret's going to talk a little bit more in a second about some of the reasons that this doesn't make sense in terms of what courts have the power to do. But in general, the reason this is wrong is because the legislature and the courts share decision making when it comes to a lot of court procedures. So courts do have lots of inherent power. For example, they have the power to set someone's sentence if somebody is sentenced to prison. And the legislature there can't encroach on that so far that they're telling judges exactly what decision to make, for example, when they're sentencing someone. But they can make rules about the procedures and the limits that are set around how a judge sets a sentence, right? So we know that legislators, for example, set mandatory maximums and minimums on sentences. And similarly, in the pretrial context, the legislature has for years and years and decades made rules about how judges use their authority to either hold people in custody or release them, what rules they have to follow, what factors they have to consider. And fundamentally, the Pretrial Fairness Act is just another one of those sets of rules. So in both cases, both the argument about bail and the argument about separation of powers, we feel very strongly that these arguments are not ultimately things that hold water. The Attorney General's office just filed their brief. I've read it. It's great. And it really lays out that from a historical perspective and from a perspective of really understanding what the law says about money bail and about how to interpret the Illinois Constitution, these arguments really don't hold water. And it's because of all of that we are fairly confident that ultimately the Supreme Court is going to find that the Kankakee Court was wrong, and the Pretrial Fairness Act is constitutional and can go into effect. Ultimately, right now, we're just waiting for that to happen. And now I believe I will pass it off to Margaret to talk a little bit about the amicus brief. Thanks, Margaret.
Well, I want to say a big thank you to Kareem and Sarah, because Kareem just gave such a helpful summary of what the Pretrial Fairness Act does. And I feel like, Sarah, that was just like such a helpful description of this current lawsuit. So that really lays the groundwork for what I'm going to talk about, which is the amicus brief filed in support of the Attorney General's brief. I'm Margaret Truesdale. I'm a civil rights attorney at Hughes, Sokol, Piers, Resnick, and Dim. It's a very long name. Sometimes we say HSPRD. And I was one of the attorneys who worked on drafting this amicus brief. Let me explain first what is an amicus brief before I dive into the substance of the arguments that we presented and the evidence we presented in our brief. An amicus brief, amicus curiae is the whole term, and that translates to friend of the court. So the amicus brief is really supposed to be an aid to the court in the court's decision making, because the idea is that the court wants to get it right when they make a decision. And sometimes there might be information outside of the parties' briefs that will illuminate the court's decision making and that the court should factor in to their decision. And so oftentimes an amicus brief will be drafted by someone with special knowledge about a particular area that sheds light on the issues before the court. And of course, the court does not have to accept an amicus brief. So the amicus brief that we filed it with a motion for leave to file the brief. So even though the brief, it was filed as an attachment to our motion, it's publicly available, but the court still has to rule to accept it into the official record and to consider it among the parties' briefs. So it is discretionary. Okay, that's what an amicus brief is generally. Our particular amicus brief supports the Attorney General's position. So the arguments that Sarah was just explaining that counter the opposition to the Pretrial Fairness Act, it was those legal arguments that we were seeking to support, and we were seeking to do that with social science research and also with the lived experience of the members and constituents and clients of the organizations that signed on to the amicus brief. So in our brief, we took on, Sarah was referencing the crime victims' rights component of the Illinois Constitution. And so our brief took on the circuit court's ruling on that issue. As part of the circuit court's ruling that the elimination of money bond was unconstitutional under that amendment, the circuit court, it relied on the assumption that the elimination of money bond was going to harm crime victims. And so we laid out for the Illinois Supreme Court the research and the anecdotal evidence showing that actually the elimination of money bond is likely to improve public safety and not endanger it. And so that in particular, even crime victims as part of the public, their safety is actually likely to improve under when money bond is eliminated, and that their safety is not likely to be endangered. And I'm going to get into that first argument and sort of a little more of detail. So the first point that we made was that in Illinois and also in jurisdictions outside Illinois, in Cook County in Illinois and then in jurisdictions outside of Illinois, there has been a drastic reduction in the use of money bond, and even in some jurisdictions, virtual elimination of money bond. In particular, in New Jersey, they have virtually eliminated money bond. And so the opponents, and even based on the circuit court's assumption, you would expect to see, a sharp increase in rearrest rates. But actually the studies show that that's not the case. The rates of rearrest during pretrial release remain consistent in those jurisdictions, despite the dramatic decrease in the use of money bond and increased release of people on their own recognizance, meaning, they'll promise to return to court, but they're not actually posting any money, or on an unsecured money bond, basically people making a promise to come back to court without actually having to post any money. So that was one thing. We showed the examples of the jurisdictions where they've reduced money bond and how it really hasn't led to public safety issues. And then we laid out the reasons why it appears likely that the elimination of money bond would be good for public safety, and why money bond may actually be detrimental to public safety. And so we explained how money bond destabilizes the lives of the people detained, as well as their families and their communities, and how this destabilization can ultimately harm public safety. And actually, Kareem alluded to some of this destabilization when he was speaking as well. And we laid it out in the brief in a bit more detail. We talk about how it can lead to job loss, housing instability, how it can harm family relationships. People who are detained often are not, it frays their bonds with their children. They're not able to care for elderly or disabled relatives. Their relationships with their spouses are damaged. It can lead to interruptions in healthcare. It can lead to very serious damage to people's mental health. And importantly, it can lead to worse outcomes in their criminal cases themselves. People who are detained pretrial are often more likely to plead guilty. They can feel an intense pressure to plead guilty just to secure their release, even if they don't believe that they would be convicted if they stood trial. And we explained how studies show that pretrial detention actually leads to higher rates of rearrest in the short term and the long term, even years after a person's case is resolved. And we believe that's likely due to these destabilizing effects of money bond and the detention that it causes. And we also explained for the court the reality that these destabilizing, these harmful effects, these harms to public safety often have the most severe impact on communities of color, which just demonstrates, just the deep unfairness of this money bond system. And then turning to our second argument, we explain that because money bond is such an ineffective tool at serving the purposes of bail, it doesn't infringe on judicial authority. Like Sarah was talking about the separation of powers argument. This was in response to that separation of powers argument, saying that, it can't be like an inherent power of the court to utilize a tool that ultimately, is ineffective at doing its job. So the purposes of bail would be to ensure that people come back to court and to promote to prevent rearrest during pretrial release, or to protect public safety during that pretrial period. And so I've sort of already gone through some of the ways in which we demonstrated that that money bond is not effective at preventing pretrial rearrest. But I do want to explain how we demonstrated in the brief that money bond is not effective at ensuring that people return to court. Studies in Illinois and in other jurisdictions show that with or without money bond, people continue appearing in court at scheduled court dates at similar rates. So it does not appear that money bond is acting as an effective incentive for people to actually come back to court. And as Kareem was mentioning, is contemplated under the PFA that there would be a system of reminders for people to come back to court. And we explained in the brief some of the social science research showing that the most effective tool for getting people to show up at the court date that is scheduled is giving them a reminder so that they know when to come back to court. Something as simple as that does not infringe on their rights in the way that detention does, and that tying up their funds does. So, okay. So those are some of the key arguments in the brief. It's available. It's good reading. So if anyone wants to read it, please go ahead and take a read. But if you find any typos, please don't let me know. Okay. So I do want to talk about who signed on to the amicus brief. Okay, great. I just saw the message in the chat. So I was counsel to the amicus, so it's not my brief. I was representing the entities and the individuals that signed on to the brief, and approved of the brief. And so those we call them amici, like the plural of amicus. So the friends of the court. Those amici, there were over 400 of them, 426 amici. And I believe 37 of them were Illinois Network for Pretrial Justice member organizations. So shout out to the Illinois Network for Pretrial Justice. These organizations and individuals include community organizations, as the slide said, public officials, researchers and academics, and faith leaders. And I'll just highlight, some of the diversity of the group of amici that joined the amicus brief. We had organizations against gender-based violence and that support victims and survivors who signed on to the brief. The organizations that signed on to the brief varied widely in terms of their area of focus, and they were both national and local organizations. The public officials included not only a public defender's office, but also state's attorneys. And so it just goes to show, I think, how broad the breadth of groups that decided that they, felt that they wanted to publicly join in to this amicus brief and into this effort, I think is a testament to how unifying the message is. So many organizations and individuals can see how harmful and illogical money bond is, and how it can and should be eliminated. So very proud to have been able to contribute to this effort and to have been trusted by this diverse group of amici to share this important information with the court. And With that, I will pass it off to Akeisha for some Q&A.
Awesome. Great job. Okay. So I have questions for Sarah and for Margaret. Okay, perfect. Here from Sarah. Awesome. Okay, first question. So now that the written arguments have been filed in this case, what happens next?
So now that the written arguments have been filed, well, to be clear, the Attorney General's office has filed their written arguments. We've filed our amicus brief. We are still waiting for the prosecutors who originally brought the case to file their brief. It's due in the middle of February. There then will be an opportunity for the Attorney General's office to reply with one more filing to reply to anything that they brought up in their brief that they didn't bring up, basically they didn't have time to address the first time they sent a filing in. After that, there will be oral argument. And after that, we will wait for the Supreme Court to make a ruling. Once the Supreme Court makes a ruling, usually it takes often about another month for that ruling to become active. So it's not like the day that the Supreme Court rules, everything changes. Instead, there will be probably some period of time after that where it will take time for the courts to actually get the orders in place and everything to actually get the law to be a go. And it will be a go everywhere, we hope, all at the same time.
Awesome. Oh, and folks in the comments, you can leave your questions. We can see them. I'll try to have them asked. Okay. Next question. How quickly can we expect a ruling? And then again, what happens after it's handed down?
Yeah, I think ruling probably anywhere from a month to 2 months after oral argument is what we're hoping on. And then, like I said, there's a waiting period after that, after the opinion is issued.
Okay.
One thing to note that I didn't say though is because this is an Illinois Supreme Court issue though, they are the final word. So we don't have to worry about it moving to further up through courts. It's not going to Brett Kavanaugh and friends.
So when it's done, it's done. Ooh. Okay. So if the court rules in favor of the Pretrial Fairness Act, what happens to the people who are incarcerated at that time?
So, good question. In December, we passed a series of changes to the Pretrial Fairness Act and what we called our trailer bill. One of the things that trailer bill did is it laid out a timeline by which people who are in custody at the time the Pretrial Fairness Act goes into effect, basically a timeline by which they will have their cases considered and will be available to be released. So for people, and basically it depends on how serious your charge is. So if you're charged with something where detention isn't even available under the Pretrial Fairness Act, that hearing happens very quickly. It could take up to 2 months for cases that are more serious. So it is not true that the day the Pretrial Fairness Act goes into effect, everybody will immediately get out. Instead, there will be a hearing in every single case where someone is in custody to figure out whether or not they will stay in custody. It's also up to the person who's in custody and their lawyer to make the decision to actually request to have their case treated under the new law. So that's something that everybody who's in custody at the time will need to work out with their lawyers. And there may be some cases where a person's actually better off under the old system, depending on the specifics of their case. So it's going to be a decision for every single person to make.
That makes sense. There's a question in the chat. David is asking what parts, if any, of the act are already in effect?
Good question. So the order from the Supreme Court put a pause on all the pretrial provisions of the Safety Act, which is basically what we understand as the Pretrial Fairness Act. It's a little unclear exactly if that covers every single provision that's related to pretrial that's in the Safety Act as a whole. One notable piece is that the electronic monitoring provisions of the Pretrial Fairness Act have been in place for a year now. They went into effect a year before the rest of the Pretrial Fairness Act was scheduled to go into effect. And at least in Cook County, those are staying in effect. Those are being treated just like normal, and this ruling is not being treated as if it affects them. So that's what we're looking at now. And everything, if you're curious, everything else that's in the Safety Act, all the policing changes, all the sentencing changes, everything else, all of that is unaffected.
Okay. All right. Next question. What would happen if the Pretrial Fairness Act is found to be unconstitutional?
That's a good question and kind of a scary question, but ultimately, it would be a major setback for the movement, and I don't think any of us on this call would say that it wouldn't be. But this is a movement that's been building for years, and it's a movement that has a ton of momentum, and we are not going to stop, and we are not going to be stopped just by a setback. So it's sort of hard to know exactly what the next step would be. It really would depend on what's in the ruling and sort of what the reasons were and a lot of things like that. But probably the next thing that would be sort of on the table would be that we would go back to our legislative champions and work to craft a law around money bond that reduced the harm of money bond as much as possible, right? So if we couldn't not have money bond at all, basically figure out a way to reduce the harm as much as possible and continue to reduce the harm caused by pretrial jailing.
I would just add to Sarah's answer that, there is a possibility that the Supreme Court would find some portions constitutional and other parts unconstitutional. The AG argued in their brief that portions of the act are severable, meaning that, some portions of the act could be struck and other portions could be still be implemented. And so, as Sarah said, you would have to see what is the ruling exactly and which components. They could break it into components.
Thank you. Okay. You answered this a bit already, Sarah, but just so it's clear for everybody, does the pause of the Pretrial Fairness Act impact all of the Safety Act or just the bail provisions? And what about
it impacts just the bail?
Okay.
Yeah, just the bail provisions. So not the sentencing provisions, and at least so far, not the electronic monitoring provisions.
Awesome. Okay, cool. We have one more question, sorry. Okay. Did the requirement of in-person custody hearing get negotiated out by amendment?
It's a good question. That's sort of separate from the lawsuit, but in December, there were changes made to the bill that made it easier in courts where there are technical challenges or administrative challenges that make it hard to have in-person hearings. So like staffing challenges, for example, it did create a provision where those counties can basically ask the Supreme Court, the Illinois Supreme Court, to let them keep having video hearings. And they have to basically renew that ask every 6 months and say, here's all the ways we're trying to fix this so that we can have in-person hearings. And can you please, let us keep doing it? So it is a little easier than it was under the original bill to have video hearings, but there are still safeguards to make sure that as much as possible, we hope that we will have as many in-person hearings as possible.
Yeah. Thanks, y'all. Those are all the questions I'm seeing in the chat. So this concludes our question and answer section. Thanks so much for answering the questions. And we're going to move on to how y'all can support the Pretrial Fairness Act. Okay, so people ask in the comments how they can be supporting the act as we wait for things to go through. So our legislators have consistently been attacked by conservatives for doing what's best for our communities. So you can use the link that we're going to drop in the chat to easily send a quick thank you letter to your legislator and the governor for supporting the Pretrial Fairness Act. It's really important that we continue to remind them how many people support this law, because we are bound to see further attempts to roll it back or repeal the legislature. Okay, we are confident that we're going to win the Pretrial Fairness Act and it'll take effect. But when it does, people who are wrongfully incarcerated for months on unaffordable bonds will have the opportunity to return home to their families. So we're raising money for the Chicago Community Jail Support. They are currently outside, like truly right now, they are outside of the Cook County Jail, providing that first warm handoff out of the jail and back into communities. They provide warm clothing, they provide food, snacks, someone to wait with you while your rides coming, pick you up. So you can support them by doing a donation or purchasing a t-shirt, and all the money will go towards getting folks home, as well as making sure they have those resources when they first get out the jail. And then last but not least, you can sign into our newsletter, We have a lot of opportunities coming up in the next couple of months, and we're going to need people like you who are educated and interested in the bill to join us in canvassing, phone banking, and more. And then with that, we're going to close out. Thank you so much for joining us this evening and for supporting the Pretrial Fairness Act. Thanks. Have a good night.